Today, we are going to read a Reddit post, I know, God forbid, from a very frustrated employment lawyer entitled Employment Lawyer ... I'm tired. I've been doing plaintiff side employment law for 17 years. I'm tired, bro. I just feel like the laws have been interpreted into oblivion by judges who hate them, and it's getting impossible to practice in as an area. Take the ADA, forget it. It's so full of vague, interpretable language, deference to the employer, discretion, and defenses that it's like a joke trying to get one of these done. Oh, he has a medical condition. Prove it's a covered disability with a 3-part subtest. Got through that? Okay, now prove you can do the job with a list of 7 factors. Oh, got that? Okay. He didn't request an accommodation. You lose. It goes on and on. Title VII is a little better. Excuse me. It's not too much better. I had a case with 21 separate instances of verbal discrimination against a black female. Judge killed it on a motion for summary judgment. No reasonable jury would find that a hostile work environment existed. I had an age case, 6 affidavits from witnesses all saying the perpetrator was doing ageist things. Motion for summary judgment. She wasn't the decision maker who fired him, although she fed information to the decision maker. Court says cat's paw is too attenuated. Guy has valid prescription for medical marijuana, fired for hot drug test. Appellate court affirms dismissal because employer had a valid zero tolerance policy. If that's bad enough, you get a case through a motion for summary judgment. Let me tell you about how the mitigation rule will kill damages completely. Then, every single client wants 1 million plus. I tell them no, expect 50K, etc. Well, you must be a bad lawyer. It's just exhausting. This entire area of the law needs a massive overhaul. I'm thinking of switching to car accidents. And the very first comment, this is probably funny, move to California. Second comment, I was just going to say, California employment plaintiff side lawyer, it's almost unfair to the employer. Almost. All right, so look, this is real. Summary judgment is a motion where the defendant says this case is such a BS case that it should never see a jury. There's just no dispute of fact here. And over time, the case law on this in many jurisdictions has gotten increasingly employer-friendly. And, it's tempting to dunk on this guy and say, like, oh, he isn't that good. And if he was better at prosecuting or picking cases, this wouldn't happen to him. In my young career, I have yet to lose an employment law case on summary judgment. But that could change in the future. I'm sure eventually it will. So summary judgment is the biggest weapon in the employer's toolbox, and oftentimes the real money will show up after summary judgment. So what can we say here? This is real. And I think the solution to this is to find a lawyer who is thinking about the summary judgment motion from the very beginning of the case and is looking to the relevant appellate precedents. So for the court that's sitting above the court that you're in, that will control what that judge gets to do. So when you oppose the summary judgment motion, the message is clear to the trial judge. If you rule against me, the employee, the appellate court is going to reverse you. So you need to be looking for a case and framing the case in the way where the appellate standards say that you have to win. Anything less than that, I think a hostile judge could kill your case. If it's a jump ball, you'll get a decision saying that it's a BS case, it shouldn't move forward to a jury. And then you have an uphill battle to turn that over on appeal. I mean, just think about it. When the case gets appealed and goes to the appellate court or the circuit court, you're looking at it from the appellate judge's point of view, and there's already a big important person like a judge, a trial judge, let's say it's a federal judge, who's already said this case is bogus. You're creating an uphill battle. So you have to begin with the end in mind, which is ultimately trial, but before trial, before you ever get to think about trial, you got to think, how does this case get past summary judgment? And if you can't do that, if you can't get the case past summary judgment, it's probably not a good case to move forward on. I would say don't pick that case and begin the case by comparing the facts you have and what you can prove to what the appellate courts are going to require. For people with claims out there, I would say ask your lawyer from day one, what's your plan to get this case past summary judgment? And to the lawyer who's probably having a bad day out there and who's frustrated, keep the faith, keep fighting, and maybe move to California.